Hospital Association. Among us are two board members. My name is Dr. Job Obwaka. I'm one of the board members. And the CPA, and Julia too, on my left, is also a board member. So we two of us are here on behalf of the board. Then we have the other members of the Kenya Hospital Association sitting with us. Thank you for coming. It's a pleasure that you are able to rise to the occasion at very short notice. But the whole idea of holding a press is to bring you up to speed with regard to the state of the Nairobi Hospital. Once the mayor health institution that seems to be going down the drain with imminent possibility of a collapse and sort of disorder. We found it necessary just to put things into perspective. So what I'm going to read here is a statement that is coming from the board, even if it is part of the board, represents what is on the ground and the facts stand as they are in this particular statement. So I'll go ahead and read the statement so that for your own consumption and for your transmission as you see fit. So the statement goes, we are concerned on the and continuing disregard of subsisting High Court orders and the governance crisis at the Nairobi Hospital. The admitting staff association that is known in the office of the Nairobi Hospital and members of the Kenya Hospital Association, KHA, address the public on a grave and escalating governance crisis at the Nairobi Hospital. One marked by open and continuing disregard of binding orders of the High Court of Kenya, institutional stability, financial imprudence, and serious governance irregularities. This matter concerns obedience to court orders, constitutionalism, judiciary responsibility, and the integrity of our national medical institution. Let's look at the chronology of things, particularly in the High Court. Chronology of binding High Court orders. On the 3rd July 2025, reference there, the High Court issued interim conservatory orders restraining the defendants from convening or continuing with the board meetings and retreats. These orders were clear, binding, and have never been set aside. On the 5th of November 2025, referenced, the High Court issued further conservatory orders restraining the defendants from convening meetings of the board of management, its committees and subcommittees, and from undertaking specific governance actions. On the 20th of November 2025, the court issued formal directions. At paragraph 10, the court directed that its ruling would address both the application and the preliminary objection. At paragraph 11, the court expressly extended the interim orders pending that ruling. The legal effect was clear. The restraining orders of the 3rd of July and 5th of November 2025 remained uninterrupted, binding and operational. On the 16th of December 2025, referenced, the High Court issued further authoritative interim conservatory orders. The court stayed all resolutions and decisions arising from board meetings held on the 19th of September 2025 and 23rd of October 2025 and 11th December 2025, and expressly reminded all parties that the earlier interim orders had neither lapsed nor been set aside, and therefore remain in full force and must be obeyed. The court could not have been clearer than that. Yet, despite the judicial record, the company secretary, one Mr. Gilbert Nyamwea, who is a named defendant in these proceedings and expressly restrained, continues to act as if court orders do not exist. Mandatory leave and refusal to comply with the same. On the 30th of June 2025, Dr. Buckley Onyame was officially removed as board chair through a special meeting of the Board of Management that was properly convened in strict accordance with the hospital's governing legal instruments. Yet he has refused to vacate the position. Subsequently, on the 14th of July 2025, following a special board management meeting convened in consideration of the subsisting High Court orders, both the company secretary, Mr. Gilbert Nyamwea, and the Chief Executive Officer, Mr. Felix Osano, were lawfully, I emphasize, lawfully placed on mandatory leave. Despite this lawful board decision, both officers have refused to proceed on mandatory leave and continue to purport to exercise authority, raising serious and unavoidable questions as to where they derive protection from, who shields them from compliance with duly constituted board decisions. Binding High Court orders and under the what authority restrained and lawfully removed officers continue to act in open defiance of both governance instruments and judicial directives. Illegal co-option of the state and state house concerns. Equally troubling is the recent co-option of individuals associated with the State House into the Board of Management, and circumstances that raise serious legal and ethical concerns. These co-options have occurred while subsisting court orders restrain governance alterations. Some of the individuals so seated are conflicted, directly or indirectly involved in commercial dealings with the hospital through proxy individuals and fictitious arrangements. This presents profound conflict of interest concerns, where board members or their associates conduct business with the hospital, whether directly, indirectly, or through intermediaries. The integrity of procurement, insurance relationships, and financial management becomes compromised. The public is therefore entitled to ask under what authority were these options undertaken while binding court orders were enforced. What role, if any, does State House play in this conflict? What is the position of the President and the officials of Harambee House regarding governance of the Nairobi Hospital? Are they aware that court orders are being disregarded? Do they endorse these actions, or will they affirm their commitment to constitutionalism and the rule of law? The silence of the executive in the face of national governance crisis of a premier national facility, I may add here, international facility, only deepens the public concern. Institutional collapse and financial distress. Further compounding the governance crisis is the alarming financial deterioration of the premier national public facility. The hospital recording a loss of over 3 billion in the year 2024, with suppliers owed in excess of Kenya's 4 billion, leading to several suppliers suspending supply of medicine, drugs, and other essential medical commodities. Patients are increasingly complaining of substandard medicine and drug shortages. The institution has effectively been turned into a construction site, with aggressive capital projects being undertaken at the expense of core clinical needs and patient care. Under circumstances that raise serious questions about possible kickbacks and commissions, there are credible concerns that new HMIS systems are being procured at prices reportedly more than 10 times prevailing market rates, allegedly to facilitate commissions. Yet the current HMIS system has not been fully deployed, and approximately 54% of its operational capacity remains unused. Similarly, pricing of the PET CT scan equipment has been significantly exaggerated beyond reasonable market benchmarks. At the same time, the hospital is reportedly in the process of seeking to borrow over Kenya shillings 5 billion, despite serious questions as to whether it presently qualifies as an ongoing concern. Close to Kenya shillings 1 billion has reportedly been expended on legal fees, much of it arising from unnecessary and avoidable litigation. There are growing concerns about collusive cases between company secretary and certain external lawyers, matters allegedly not being properly defended due to conflicts of interest involving the company secretary himself. An escalating contempt proceeding that could otherwise have been avoided had subsisting court orders been obeyed. This pattern reflects not financial stewardship, but institutional distress, manipulation of judicial processes,